Robertson, who appeared as a guest on HGP TV's Beyond the Surface, made known his and the APNU AFC's resolve on the matter of the election petition.
And we thought that we had advanced substantial arguments to support our position. The court didn't agree with us, but we still feel very strongly that we are right on the law.
Robertson was asked if anything at all went awry in the APNU AFC's legal camp, which resulted in the petitions being dismissed.
Would you say that things went awry in the APNU AFC camp regarding the merits of the petition 88?
Oh, not at all. Not at all. I think the arguments were well thought out. I think the arguments were sound. I think the arguments were very well presented. The court didn't happen to agree with us.
The attorney at law reiterated the arguments proffered by his legal team that Section 22 via Act No. 15 of 2000 does not allow for true separation of powers. He explained that every democracy the world over is founded on the principle of separation of powers, where the executive does not impinge on the judicial nor legislative arms of government. However, in Ghana's case, and more specifically the 2020 election, he said, highlighted the country's flaw in that regard. Robertson explained that while GCAM has the authority to do all that is necessary within its power to remove difficulties arising from any election, it cannot and should not have the authority to amend laws, as that power resides with Parliament, which is the legislative arm of the government.
And what we have in the case of Section 22 is an attempt to delegate to GCAM the right to change the very law that they are put to administering.
Robertson stated during the interview that electoral as well as constitutional reform is needed, so that the language of the Constitution could be much more clear. He submitted that had the language of the law been more pellucid, the country might not have seen the many court battles which ensued following the elections. Asked whether there is anything else that could be done should the two election petitions fail to be successfully appealed all the way to the CCJ, Robertson said that the petitioners would have no other choice but to abide by the ruling of the CCJ, as it is Ghana's apex court.
You can't lose, even if the petition is not ultimately successful. What we would have, we hope, is a final, clear decision as to what our election law means, whether or not Section 22 is constitutional, whether if the same thing were to arise in the next election, whether we could just cull together a group of people to do a recount. Those things need to be determined one way or the other. So,
Wendell Badrie, HGP Nightly News.